Alrighty, thank you all. Good evening. It is currently 5:43 on November 10th, 2010. And this is an informal public hearing of the City of Urbana's Human Relations Commission. Could we please have a roll call?
Daniel Larson,
Here.
Aisha Lamb-Sobe,
Here.
Jeff Bant,
Here.
James Simon,
Here.
Christopher Hansen.
Here.
Thank you all. Thank you, Tamara. Good evening again. My name is Daniel Larson. I am a member of the Urbana Human Relations Commission. And for tonight's gathering, I've been designated the chairperson for this informal hearing. I want to thank Aisha and Jeff both for joining me for this hearing. Thank you both. Tonight, per the City Code sections 1982 D and E, we are listening and discussing Mr. Christopher Hansen's appeal to Mr. Jim Simon's September 2020 initial determination and order. I believe we've designated this matter number 001-09-20. Personally, I would like to also thank, having never organized such an event, I would like to thank Tamara, Jason, and other staff members here in the city building for helping me organize and schedule this hearing. So let's begin. We are going to, the sort of bulk of this hearing will be a 15-minute officer statement, up to 15 minutes for Mr. Simon. That will be followed by the complainant's statement of objections, up to 20 minutes. Then we will have a short officer's reply. And then we're going to have some questions here from the hearing body. We're going to open the event up to the public for some public input. And we're going to also have some questions and deliberations. So, I think I've set that up properly. Sorry, a little clumsily, but I'm going to turn it over to Mr. Simon and his opening statement. Thank you.
Thank you. Thank you for all three of you for volunteering to conduct this informal hearing. Normally, the Human Relations Officer would be handling this matter, but that office is vacant, so the mayor asked me if I would handle it, and I said I would. My task initially was to investigate the complaint to determine whether the Human Relations Commission has jurisdiction over both the matter and the respondents. I also was tasked with determining whether probable cause existed that any one or more of the 5 respondents committed a discriminatory act against the complainant. I prepared a report of proceedings that I believe all of you, including the complainant, has received. Based on my investigation, I found that the HRC does not have jurisdiction for any one of 3 reasons, and I'll get into those in a little bit. I also found that there is no probable cause that any of the 5 respondents discriminated against this particular complainant. Pursuant thereto, I entered an order, an initial order dismissing the complainant's complaint. As you rightfully have indicated, Chairman Larson, Mr. Hansen has a right to appeal, and he has done so, and that brings us here tonight. Your task is to decide whether to affirm or reverse my preliminary order. The complaint alleges that the respondent was discriminated against when the 3 Civil Service Commission member respondents approved 2 job descriptions and when 2 human resource employees posted those job descriptions in order to fill the positions. Both job descriptions, at I believe the bottom of page 5, provide that job applicants must be capable or able to pass, quote, a criminal background check. The 2 positions in consideration, by the way, are a human resources coordinator position and a human resources assistant. As I say, there are 5 respondents. 3 are board appointees or commission appointees, Civil Service Commission. 2 are employees. The Human Resources or Human Rights Ordinance bars discrimination in employment based on prior arrest and/or conviction record. Notably, the ordinance does not ban the use of criminal background checks. Rather, it bans the use of such checks in a discriminatory manner. The Human Relations Commission lacks jurisdiction for any one of three reasons. First, a logical reading of the ordinance. Second, whether the complainant himself has standing to bring this complaint. And third, whether the complaint is even ripe for determination. All three must be present, and all three are components of jurisdiction by any stretch of the imagination. Let me start out with the plain language of the ordinance. The ordinance does not apply to employees of the city or appointees of city boards and commissions. Urbana City Code Section 12-105D provides an exemption for units of government, state, federal, and local. And there is an indication in there that says, and other units of government. It's a question whether that includes the city by reference to municipal corporations or boards and commissions by reference to agency. And I am sure the complainant will argue that point. But we need not even consider that, to be honest. If you look at the fair reading of the ordinance, I think anyone would conclude that it can't apply to these five individuals. The complainant raises his complaint concerning job descriptions and the provision regarding criminal background checks. That deals with employment, and therefore he alleges a discrimination in employment. That's governed by Section 12-62 of the Human Rights Ordinance. If you read 12-62, it says it applies to employers, not employees, not appointees. The respondents are 2 employees and 3 appointees. They are not employers. Section 12-101 provides for a fine to be imposed on an employer, not an appointee, not an employee. But think about the logic of that. Let's say the city, as an employer, were subject to this ordinance. A fine could be imposed on the city, and it would be payable to the city. If the city fails to pay the city a fine, the city would have to go to ordinance violation court to pursue collection of the fine and raise the issue whether the fine was properly imposed. Thus, the city would have to sue the city to collect a fine from the city. Needless to say, that defies logic. The Commission has no jurisdiction over the 5 respondents because they are not employers. Further, Urbana City Code Sections 2-171, 2-173, and 2-174 requires the city to indemnify and defend employees and appointees to boards and commissions if complaints are filed against them seeking damages in connection with performance of their duties while employed or serving on a board or commission. Thus, the city would be the responsible party that would bring the city into the proceeding. Again, not logical to assume that the city would bring a charge or would bring a complaint in ordinance violation against itself and seek to collect the fine against itself. The fine is not awarded to the complainant pursuant to the ordinance. I dare say that the Human Relations Commission would be put in an untenable conflict of interest with city staff, the mayor, and appointees. Why? Because 12-22 requires that staff and others must support the HRC. And the HRC must cooperate with the mayor, city departments, obviously who are staffed by employees, and other agencies, boards and commissions. All services of city departments must be available to the HRC. Thus, while the HRC is in the midst of investigating employees, as complainant would suggest, they are forced to work with one another. An untenable unintended conflict of interest. As will be discussed in a minute, this complainant lacks standing to even bring the charge that he has brought or the complaint he has brought. Plus, the complaint is not even right. There is no probable cause found that any discriminatory act was committed regarding this particular complainant. Elements of probable cause include standing and rightness. As I indicated, Ordinance Section 12-62 govern this proceeding because that deals with discrimination in employment. That section contemplates that the discrimination must have been directed at a particular person, not just some general broad, well, maybe there might be a discrimination generally by, for instance, adopting a job description. Section 12-62A1 provides that an employer may not discriminate with respect to job applications or hiring decisions. Section 12-62C provides that the ordinance prohibits employers from using job applications to elicit information for a reason based wholly or partially on discrimination. There is nothing in these two sections or any other part of 12-62 that prohibits an employer from using background checks, including criminal background checks. What is prohibited is the use of information in a discriminatory manner or the use of background checks in a discriminatory manner. For instance, if an employer requires a prospective employee to submit to a criminal background check because he is a dock clerk at Walmart, unloading trucks at Walmart, and he's required to go through a criminal background check, but the same white individual who applies for that job, same job, is not required, that is a discriminatory act. There's no standing here, and it's not ripe. Why? Because the complainant does not allege that he even bothered to request a job application regarding either of these two jobs. He did not apply for either position. He was not given a contingent offer for either position on the condition of passing a criminal background check. He was not asked to submit to a criminal background check. The city did not conduct one on him. His contingent offer, which was never made, of course, was not revoked because of the contents of a criminal background check. And he was not denied employment because of a criminal background check. In short, he never bothered to apply. So it's not even ripe for determination. Further, the positions were posted internally, not externally. To my knowledge, the complainant is not an employee of the city and therefore did not have an opportunity to apply for either job. By the way, they were filled with city employees. So he has no standing. He's not alleged any discriminatory act committed directly to him. He has not alleged that an employer has committed any act, and therefore he has no standing, and as I say, this matter is not right. The city has a lawful right to require criminal background checks in certain instances. Section 12-39 defines discrimination in relevant part as any practice or act which is unlawfully based, wholly or partially, on prior arrest or conviction record or of any individual, i.e. the information in the background check being used in a discriminatory manner. The city follows EEOC guidelines on how to use criminal background checks. Their publication was published in 2012. The respondent, Elizabeth Borman, handles hiring for the city, and she advised this investigator that not all jobs require criminal background checks, but some do. Those where the employee who fills the position will be handling sensitive information or confidential information, such as financial information, bank account information for direct deposit of paychecks, Social Security numbers on W-2s and W-4s, home addresses, home telephone numbers, home email addresses, information relating to employees who are covered under one or more benefits, information relating to financial issues of retirement plans, information relating to employee discipline, health information, people covered by the health plans. Likewise, job descriptions or jobs that are going to require access to, for instance, personal residences for property maintenance code inspections, or rental registration inspections, or schools, or private businesses. Schools, for instance, for the placement of student resource officers or school resource officers, inspections of private businesses for building code violations, fire violations, safety violations, or that where the information is protected by state or federal law, including exemptions applicable to FOIA requests under federal FOIA and state FOIA. The city confirms the accuracy of the information in a background check and gives the candidate the opportunity to discuss it and to explain why whatever is found in that check will not in any way prevent that person from providing the services or duties required in employment. Indeed, federal courts have recognized criminal background checks as a viable and appropriate step for employers. And that includes the United States Supreme Court in National Aeronautics and Space Administration versus Nelson, where the court recognized the long history of employers conducting background checks to ensure security and indeed competence of the employees. And likewise in Hernandez versus William Rainey Harper, the Northern District in Illinois, a federal court up north, also confirmed and approved the use of criminal background checks. What they indicated was the use of the information in a discriminatory manner is a problem. Now, mind you, that doesn't leave this complainant without a remedy. If he can't avail himself of this ordinance, he is not without a remedy unless the law gives him no remedy. The complainant can file a charge with the Illinois Department of Human Rights, with the federal EEOC, Equal Employment Opportunity Commission, or file a state or federal discrimination claim. I dare say, however, the complainant will have to meet the same standing and ripeness requirement in all four forums that he is unable to meet here. Therefore, I kindly request that you affirm my order. There is no jurisdiction lodged with the HRC, and there is no probable cause that any of these employees and appointees committed a discriminatory act. Thank you.
Thank you, Mr. Simon. If I could just make one slight update, I forgot to mention in my introduction, I did want to just let everybody know that per the ordinance and the procedures of the appeal process, all the respondents were invited to this hearing tonight to respond to Mr. Simon's determination. That invitation was put out. All the respondents respectfully declined to make that response tonight. I apologize for not including that in my introduction and disrupting the body of the hearing, but I felt like I just wanted to make sure that got on the record. I apologize. Mr. Hanson, we are going to turn it over to you for your response, please.
Hello, my name is Christopher Hanson. I've been an Urbana resident for 18 years. Mr. Simon, I think, has done a fairly fair job of introducing why we're here and the nature of the complaint. The nature of the complaint is that the members of the Urbana Civil Service Commission, along with their associated staff, produced a number of circulated job requirements that required that the applicants must pass a criminal background check. That requirement listed on that application is a violation of the Urbana Human Rights Ordinance. Now, Mr. Simon stated shortly before the meeting, and to some extent in his 20 minutes, that he is here representing the city and the respondents. And my understanding is that Mr. Simon's function here as an investigating officer in place of the human rights officer is to some extent to advocate for the complainant and seek out an actual truth. and investigate possible discrimination. Instead, what Mr. Simon has done here is set up a number of barricades to the Human Relations Commission in the form of a variety of technical hazards that are almost entirely the inventions of Mr. Simon and have little to do with the intent and spirit of the Human Rights Ordinance. Mr. Simon, in his response letter, refers to a previous similar hearing, and I'm not sure he mentioned it much at all tonight, but I will respond to it since it's in his determination letter for this hearing. There was a previous hearing which looked somewhat similar to this issue, and that body voted for no jurisdiction. And I would like to point out why we need not or should not look at that hearing determination, and the number one reason is that that hearing body was wrong. It was not a unanimous vote. One of the members of that hearing body, Marion Knight, is named in this complaint because he has been engaged in illegal discrimination, and I don't see the reason to trust that opinion. The third member, Pete Resnick, co-chair of the Human Relations Commission, cast his vote on the basis of the definition of public accommodation, which has, well, it didn't make sense at the time, and it has absolutely nothing to do with this particular issue. That hearing was about a different complaint, which does not make the same claims as this new complaint, and that's why we're holding this new hearing so that this hearing body can make their own determination. Mr. Simon has claimed that the HR ordinance does not specifically contemplate application to city employees. The HR ordinance, the Human Rights Ordinance, does not contemplate application to anything specific at all. It doesn't mention specific employers. Mr. Simon brought up Walmart. It doesn't mention Busey Bank or Crane Alley or Holiday Inn. It doesn't mention restaurants, stores, bars, banks, hotels, or even contain any of those words. What it does do is cast a very wide net for all manner of complaints that allege discrimination. In each instance where the ordinance provides for certain types of discrimination, or in certain instances, it also provides that the ordinance is not limited to those instances. It repeats that throughout the ordinance. Luckily, we don't have to speculate on this matter because the ordinance actually does address it specifically. In section 12-37, the ordinance defines an employer as, quote, any person who for compensation employs any individual. And then it defines person as one or more individuals, labor unions, employers, employment agencies, partnerships, associations, creditors, corporations, cooperatives, legal representatives, government agency, trustees, owner, or any agent or representative of any of the foregoing. So it does include government agencies, and an employer is any one of those types of persons. The ordinance definition clearly includes government agency, and it clearly defines those. We can also look at section 12-22, and it reads, the Commission on Human Relations shall cooperate with the mayor, city council, city departments, agencies, and officials in securing the furnishings of equal services to all residents, and then it goes on to say, and maintaining equality of opportunity for employment and advancement in the city government. The ordinance specifically cites the exact instance that we're talking about. And it seems rather obvious from the context that city government means the Urbana city government. So not only does the ordinance define the respondents as being subject to the ordinance, but it also specifically tasks the Human Relations Commission with handling complaints in regards to city employment practices, which is exactly the type of complaint that I've filed. Mr. Simon means to confuse the issue by bringing up an exception cited in section 12-105D of the ordinance, which says, the provisions of this article shall not apply to other units of government, including the federal government or any of its agencies, the state of Illinois, etc. Mr. Simon has interpreted this to mean that the HR ordinance doesn't apply to the Urbana government. This sentence clearly means exactly what it says. Having already mentioned and included the Urbana city government in regards to employment, this section says the HRO does not apply to other governmental entities. For example, the federal courthouse or the post office, both of which reside in Urbana. If the HRO ordinance actually intended that it would not apply to city employees, it would simply say so in plain language. I cannot believe that when this ordinance was crafted, the intention was that city employees would be exempt and be allowed to discriminate against residents in their performance of their public duties and in hiring. Mr. Simon cited section 12-62, in order to confuse the definition of employer, but it is clear that the definition of employer also extends to their agents in the extent to that they go out and hire people or create job descriptions. Mr. Simon has argued that the HRO can't apply to city employees because the ordinance indicates a $500 fine for violations, and the city paying itself a $500 fine might cause some kind of unfathomable paradox. Mr. Simon says this, quote, defies logic. The HR ordinance was never designed to be a revenue-producing ordinance. It has little to do with revenue, nothing to do with revenue, really, and everything to do with equal access and equal opportunity. The issue of a fine is a red herring, and if this aspect of Mr. Simon's denial must be discussed, then my response is I see no reason that a city employee or a board member couldn't be made to pay a fine to the city out of their own pocket. I have here a copy of the Urbana City Council Procedures and Orientation. I printed this out today. It's for the year 2020, and it was authored by James L. Simon, that's the city attorney sitting here, and Charles Smith, who was a city clerk at the time. In that procedures manual, it talks about fining a city council member $200 to compel them to attend city council meetings so that the council can attain a quorum. This is if a city council member, I suppose, goes rogue and doesn't attend meetings. So we do have a precedent for fining people on boards and commissions. More to the point, I have here a copy of the City of Urbana Officials and Employees Ethics Ordinance. In this ordinance, it defines city appointee, which means a person appointed by the mayor and confirmed by the city council to a position in or with any of the City of Urbana's boards, commissions, panels, or other bodies. It defines elected official, which means the mayor, elected or appointed members of the city council, the clerk, and any other person holding elected office within the city. It defines employee, which means any person employed by the city, whether full-time, part-time, seasonally, pursuant to a contract, or otherwise. This ethics ordinance goes on to talk about issues such as accepting gifts and a number of other issues related to the city, where the city wishes to regulate what employees and board members can and can't do in order to keep our ethics issues straightforward. On the very last page of this ordinance, section 2-209, it talks about penalties, and it says, quote, a person who intentionally violates any provision of this article may be fined in an amount not to exceed $750. So the precedent for fining elected officials, city council members, the mayor, board members, appointees, city employees, whether part-time or full-time, is already established in ordinance. I don't know why Mr. Simon is claiming that it's somehow untenable or impossible that we might fine them. This ethics ordinance is meant to be applied by the city ethics officer. That person happens to be Mr. Simon, so he knows very well that fines can be applied to any of these people. Again, it's a red herring. I'm not here for any money. I don't care about fines. I want the city to hire in a non-discriminatory fashion. That's my goal. I haven't asked for any monetary compensation. Again, none of this matters. Mr. Simon concludes his jurisdiction argument by stating that a civilian group reviewing the actions of a city employee would present an untenable conflict of interest. I find this claim coming from the city attorney rather remarkable, and I wonder if Mr. Simon has heard of the Urbana Civilian Police Review Board, a city board designed with the sole intent of reviewing and correcting the actions of city employees, namely Urbana police officers. Mr. Simon has listed a number of points suggesting that there is some conflict of interest with the HRC looking at the actions of a city employee. Number one, he says the mayor, with the consent and advice of the city council, appoints the members of the commission. Well, this is the same with our Civilian Police Review Board. He also says the city staff provides support to the Human Relations Commission. This is the same with the CPRB. The commission is charged with cooperating with the mayor, city council, city departments, agencies, and officials. This is the same with the CPRB. The services of all city departments and agencies shall be made available to the commission at its request. This does not describe a circumstance or conflict any different than might be encountered with our Civilian Police Review Board. By not allowing a complaint against a city employee to be investigated, the long-term effect would be to create an even worse internal conflict. The HRC would be forever operating with the suggestion of impropriety by the very resources on which it relies. The HRC must investigate complaints against city employees, if only to ensure that its own tools are sound and trustworthy. A very simple fact is the reason that we have civilian review boards like the HRC is because we recognize the tendency for institutions to fail internally. By leaving this matter to internal mechanisms rather than a more external civilian board, such as the HR Commission, the conflict of interest quandary cited by Mr. Simon will be substantially worse. Furthermore, if I'm following Mr. Simon's logic, he is arguing that because of these conflicts of interest, the Human Relations Commission is not just barred from hearing a discrimination complaint in regards to city business, but the HRC would also not be able to hear a discrimination complaint about any person related to the city in regards to private business. Many of our elected officials and appointed board members own businesses and rental properties. It is possible that there could be a discrimination opportunity in the ownership of those businesses and properties. And I'd like to know if Mr. Simon is claiming that all of these people, which I think would be a few hundred people at least, are exempt from our human rights laws because they have some type of relationship with the city. We're a community. We keep each other accountable. Between our family, between our friends, our neighbors, our church, it's what we do. It is not right to try to ship this somewhere else or shirk it or shrug it off and say that we can't do this because it's hard. The right thing to...
Just want to let you know we just passed 10 minutes. Sorry to interrupt
Okay.
you.
The right thing to do is to shoulder this and to look into it. On Simon's last point in regards to other remedies that are available to me, I find this to be entirely irrelevant. We're in Urbana. We're in the Urbana City Chambers right now in the city building. I filed my complaint with the Urbana Human Relations Commission, and that is who should handle the complaint. There is nothing in the ordinance that says I should have to go someplace else. We have an Urbana Human Relations Ordinance, presumably for a reason. We have a Human Relations Commission, presumably for a reason. Let's use it. I'm going to move on to the issue of probable cause now. Mr. Simon has claimed that my complaint lacks probable cause because I did not allege that I was personally victim to the discrimination. Being a direct victim to discrimination is not listed as a requirement in the Human Rights Ordinance. In fact, the ordinance allows for the Commission to activate a complaint without there being a complainant at all. This is listed in Section 12-22, B8. Quote, initiate investigations into areas of possible discrimination which might come to the attention of the Commission, although there is no individual complaint. That can activate the section on complaints, Section 12-81. So I don't even have to have filed the complaint. I could have filed an anonymous complaint, and it would have activated the complaint process. There's no requirement that I be personally victim to the discrimination. If I must make that argument, then I would argue that the widespread damage in this case is obvious. When the city discriminates in its hiring practices, all of the residents of Urbana, including myself, are robbed of the possibility of the fullest applicant pool. We are damaged by not having the opportunity to be served by the best of the possible applicants. Mr. Simon has argued that a discriminatory statement on a job requirement circulation does not prove that someone actually discriminated. Before filing my complaint, I did check with the chair of the Urbana Human Relations Commission, Francis Rigberg, on the exact issue of placing a criminal background check requirement on a job circulation. In an email, I asked Ms. Rigberg, quote, if an employer publicly posts that a requirement of employment is that the employee must pass a criminal background check, is that a violation? Francis Rigberg responded, it seems to me that putting that requirement in an ad is meant to and would in fact discourage people with a record, and this is against the spirit, if not the letter of the ordinance, and likely would not stand. We're having the same problem with housing ads, and along with Danielle, we are working on it. It's wrong on the face of it. So I find it rather impressive that the chair of the Human Relations Commission, an expert on the Human Relations Ordinance, finds it to be a very likely violation, whereas James Simon won't even admit that there is even enough probable cause to investigate the issue. So let's suppose Mr. Simon is right, and that putting a discriminatory statement on a job description is not a violation, and does not even indicate a likely violation. That would mean that someone could put a now hiring sign on the window of their business, and the sign could say something like, all applicants must be white. Now, we'd have an expectation that when a non-white person saw that sign, saw that requirement, they may not apply for the job. And there won't have been any violation, according to Mr. Simon, because we could never prove that there was actually any discrimination because we can't prove a negative. And I wonder if this hearing body is willing to accept that interpretation of the ordinance. The nasty part of discrimination, frequently, when you make a discriminatory statement like that, is that you'll never actually get to see exactly what damage it caused. That's what makes it so kind of nasty and destructive to the community. Instead of actually investigating my complaint, Mr. Simon has made a long list of things that I have not alleged. It stands to reason that the purpose here is to argue that I don't have enough information to justify my complaint. I would be more than happy to submit public records requests and review the records myself. Unfortunately, Mr. Simon and his legal staff have recently started engaging in all manner of illegal activity in regards to FOIA requests, and I have many letters from the Illinois Attorney General indicating those violations. It takes me about 5 to 6 months now to receive public records from the city of Urbana, if I can ever get them at all. Now, if Mr. Simon wants to claim that I haven't discovered a violation because I haven't provided enough evidence, then I can start submitting those FOIA requests, and this ordinance allows me to submit another complaint so long as I discover the violation within 1 year. So I can do that, and we can start this all over again if we really want to. But I think the violation is obvious already. Mr. Simon has made a number of legal citations that have nothing to do with the Urbana Human Rights Ordinance. Again, we have our own ordinance. We have our own commission. That's what we're here to look at now. We're not here to look at what a court in California or New York has allowed or what a federal court has allowed. Presumably, we have our own human rights ordinance because we like to think of ourselves as progressive in that manner, and we like to think that we can do better than the bare minimum. Mr. Simon also wishes to entertain a number of hypotheticals in order to argue that why criminal background checks are useful. I'm sure that could be an interesting conversation, but the fact is that the Urbana Human Rights Ordinance specifically prohibits discrimination based on criminal record and does not give any exceptions. And it certainly doesn't allow discriminatory statements to be made on job listings. In closing, I'd like to draw attention to what is happening here and how unapproachable this process is for an Urbana resident. I was told that I couldn't have any legal representation at this hearing, so I have to argue against the city attorney, who is twice my age and has 35 years of legal experience. And all we're hearing is that the city does not want to hear about discrimination. When an Urbana resident finds something that looks discriminatory, we're hearing that that person needs to go away and that needs to be dismissed and not looked at by the Urbana Human Relations Commission. This type of matter is exactly why the Human Relations Commission exists. It's written directly into your ordinance over and over. The fact that we're here, this hearing, this is a travesty. This should have been looked at months ago when I first submitted the complaint. Instead, every effort has been made by the city to essentially tell me to go away. So I'll close it there, and I'd like to make one suggestion, if I could, to the hearing body, and my suggestion is you, as a body, can vote not to follow the established public input rules. You have a time limit of 4 minutes. We're here to discuss one simple issue, and my suggestion to the body is perhaps you could vote not to follow the 4-minute time limit so that people can just speak, and not have to watch that clock. I think that'd be a nice thing to do. Thank you.
Thank you. Mr. Simon, you have 5 minutes for a reply, please.
Thank you. I'd like to address just a few points of distorted logic and interpretation that Mr. Hansen chooses to apply. Section 12-39 defines employer, not just any person, but any person who employs any individual for compensation. These respondents don't employ any individual for compensation. They are not employers. So Mr. Hansen's twisted logic doesn't fit. Section 12-62 speaks in terms of employers. An employer, that's a defined term, as he points out. He just doesn't define it fully the way the ordinance defines it. It says, Section 12-62A1 says, it is, well, actually the introduction is just as relevant. It shall be unlawful practice for an employer, i.e. somebody who employs individuals for compensation. For an employer to do any of the following acts for reason based wholly or partially on discrimination. And I already discussed subpart 2, to refuse to hire or discharge or to accord adverse, unlawful, or unequal treatment to any person with respect to his or her application. A specific person, not just some roving inquisition that the complainant asks you to engage in. This is not a roving inquisition. The HRC can change or ask the city council to change the ordinance if it feels that it is too narrow. But we're dealing with the ordinance as it is written. Section B talks about job applications. An employer who treats an individual improperly with a job application requirement. Not some roving commission, not some roving inquisition, not some knight errant searching for a cause. Mr. Hansen brings up the CPRB and the fact that it looks into police issues. This is not the CPRB ordinance. That is an ordinance that specifically identifies that it can look into actions and conduct or misconduct by police officers. This ordinance doesn't say that. To use Mr. Hansen's logic elsewhere, if it was intended by the council when they adopted this HRO to include the city, it would have done so, or city employees, it would have done so, or to include appointees. Mr. Hansen brings up FOIA, which has absolutely nothing to do with the HRO. Mr. Hansen is on a crusade. I respect that. He has a right to speak vigorously
Two more
and,
minutes, sir.
thank you, forcefully for his issues and his causes. That's what America is all about. But we also have the rule of law and the language of an ordinance. There are a legion of cases that provide that we interpret ordinances by their plain language and not by what we would like them to say. There's a lot in this ordinance that I would like to change. Maybe Mr. Hansen and I would agree on some changes. I don't know. But the fact is, this is the language. These are the definitions. Section 12-62 seems to apply. Thank you.
Thank you, Mr. Simon. Alrighty, we are going to be moving forward to public input. I believe that I could make the decision to alter the rules as the chairperson for this evening for public input, as Mr. Hansen put forward. But I would like to hear from my fellow panelists. Would you like to proceed with the current public input guidelines, or would you, Jeff and Aisha, like to possibly waive those for tonight's hearing?
I would support waiving those for tonight's hearing.
Yeah, that's fine for me too.
All righty. We will do that. I will say this, Jim, Mr. Simon, pardon me.
With all due respect, I believe Mr. Hansen is wrong.
Okay.
The Open Meetings Act provides section 2-06(G)
I guess I should.
that public input is to be governed by rules. If you waive the rules that you've adopted on your agenda, then you have no rules except whatever the board wishes to choose to make up or have a party, whether it's me or Mr. Hansen, suggest. So I think you do have to follow the rules as they appear on your
The
agenda.
Urbana City Council has waived public input rules in the past. I think the new rules that were just passed by this council.
Mr. Hansen, I would respectfully request that you do not interrupt. This is your custom and practice, and it is not acceptable in this instance. Let me finish. Thank you. The fact is, you are obligated under rules set forth by, in this case, a new ordinance, or what's listed on your agenda. If you change them, then you're not operating under established rules.
Are you done?
Yes, thank you.
I don't know why you said it was my custom and practice to interrupt. We've literally interacted twice ever in our lives. My understanding of the rules is that it's a majority of the public body can vote to not enforce that 4-minute time limit. I'm surprised at what Mr. Simon is saying because I've seen the Urbana City Council do exactly that. I've also seen other boards do exactly that. So this is surprising to me. I mean, we can look it up right now.
Well, I'm in a little bit of also a gray area. Are we currently in a board meeting or a city council meeting? This is an informal public hearing of 3 members. I don't believe,
It's a public body meeting.
Okay,
The
thank you.
the statute applies to public bodies.
Sure.
It makes no comment about councils or boards or commissions.
Thank-
They are all public bodies, and that's what it applies.
thank you.
We put a time limit on on each person, i.e. we, instead of 4 minutes, you said 10 minutes or 15 minutes, would that take care of our violation of the rules? If we just redefined how long the time was?
By redefining how long the time limit is, there are established rules, and I'll be honest, I've not seen the agenda. If the rules are referenced in the agenda, those are your rules.
Can I read from the agenda really quickly? So for the agenda for the meeting tonight on November 10 at 5:30 p.m., an informal hearing of the Urbana Human Relations Commission. Section on public input says public comment shall be limited to no more than 4 minutes per person. The public input portion of the meeting shall not total more than 1 hour unless otherwise shortened or extended by a majority vote of the public body members present. It seems to me that you are able to, as a public body, determine if you want to follow the established rules or your own rules. It's written into your agenda.
Mr. Simon?
Frankly, I would disagree. However, I will leave it up to you because the public does have a right to speak, and they should. I mean, this is a public meeting, so let them speak.
Thank you. Jeff?
Can I call the agenda here, before the public input, it's supposed to be hearing bodies' questions to the presenters. Did we just forget about that, or are we going to do that later?
Wow. Jeff, thank you. I skipped over, I apologize, I got ahead of myself. That's purely a misread on my part.
Okay.
We do have hearing body questions first, and that is critical. But should we, while we're on the issue, do we want to resolve it now or come back to it after we get done with our questions?
You mean the public input?
Correct.
Yeah, we can resolve that now. I just had a question about
Thank you
something.
for pointing that out. I got ahead of myself. So Jeff, I believe you put out the notion of possibly maybe doubling the time limit from 4 to 8 minutes possibly for each public input participant?
So do we have a list of public input? I mean, do we have a number of people?
Jason is going to be sort of managing that for us. I'll call to him and he will sort of
But do we know-
navigate the Zoom.
Do we know how many people we're talking about?
Could, Jason, could you possibly share with us how many people we have in the queue?
There are currently 25 attendees for public participation. Now, not all of them have their hand raised right now. Currently, only 5 people have their hand raised right now. Now, people can always raise their hand later during public input and be called upon. But right now, there's 25 total, and it looks like 4 now have their hand raised.
Mr. Simon?
Can I ask a question?
Sure.
Are you also going to extend the length of public comment? I don't mean individual speakers, but
The
the
entire-
length.
I personally feel an hour is enough, but unless that 25, unless that 4, becomes 12, and so, sorry to be
I don't expect it's likely we're going to move into an untenable amount of time. I just wanted people to be able to speak and not have to stare at a clock ticking down to 4 minutes and feel like they were rushed. So if you change it to 8 minutes, I have little expectation that people are going to speak that long. I'd just rather people not have to stare at a clock and get cut off, as has been happening at city council meetings.
Okay.
So I'd support changing it to 8 minutes.
Aisha, any thoughts, questions?
As long as, I guess, I feel like an hour should be sufficient. If there's 25 people and everybody wants 8 minutes, that's going to be, start running into longer time, right?
Correct.
Why don't we ask everyone who plans to speak to raise their hand, and then we'll know how many there are, and we can go from there.
Sounds good.
Jason, any indication?
Currently now there's 8 people with hands raised.
Keeping in mind some people are bound to speak for less than 1 minute, perhaps, so we don't really know.
Well, if we figured there were 8 people minimum and each one took 10 minutes, that's,
Hour and
or 8
20.
minutes, I'm sorry. If they, each one took 8 minutes, that's close to an hour, so.
Jim, Mr. Simon.
With people waiting for public comment, and you more or less broaching the subject of public comment, you are free to amend your agenda if you want to do the questions and answers after public comment, so people get a chance, so they don't have to wait any further.
Thank you for that suggestion. Thank you both. Man,
I didn't mean for this to turn into such a big deal. If you would change the agenda, that'd be fine with me. I don't see. I mean, maybe the public will bring up issues that this hearing body would like to ask questions about. I don't think it matters too much either way.
Personally, I'd like to hear the public participants before I would give questions to the presenters. I'd like to see what is the general, what are people concerned about over this issue? I know we're supposed to do it before the public input, but I'm just saying.
No, hearing that now, that logic actually makes sense to me. I put together the agenda, and I missed that. But I actually do like the notion of amending the agenda and flipping those two categories.
That'd
So
be fine. That'd be fine with me.
I think do I formally have to make a motion? I apologize. I move that we'll get to the time question in a second, but first off, I move that we put hearing public input at agenda item 6 and move hearing body questions to agenda item 7.
I second it.
Thank you. All those in favor, please say, oh, sorry.
Has to, because of the rules with COVID, has to be a roll call vote.
Thank you. So, thank you, Mr. Simon. Thank you. Tamara, could you please do a roll call vote?
Daniel Larson,
Aye.
Aisha Lamb Sobe,
Aye.
Jeff Bant,
Aye.
Thank you all. Thank you for your help here. All right, let's, real quick, time limit. I got to admit, I'm conflicted. We published a certain one set of rules. We were going to guidelines these, but we're also flexible. And let's remember, this is an informal hearing. So I think there is some room to possibly maneuver. I'd love to hear from the other two body presenters real quick.
I think if we left it at 8 minutes and an hour limit on the total input, then we'd be fine.
Okay, Aisha?
Yes, that's fine.
All righty, we're going to go with that. So I'm going to make a motion that we extend the public input to 8 minutes per individual with an hour, roughly an hour total. Could we please have a roll call vote?
Daniel Larson,
Aye?
Aisha Lamb Sobe,
Yes, aye.
Jeff Bant,
Aye.
Thank you all. So let's keep moving forward. We're going to move now to public input. And Jason, you're going to help me now, please. As we navigate, Jason's going to identify each public participant with their hand up and get them sort of cued into the meeting. So Jason, thank you very much. And could you please add our first public participant, please?
Yeah, so first up is Sarah Nixon.
So I was afraid you were going to say that, Jason. And I would like to request that you shift me over to the last position. I am one who had fully expected the gathering or meeting or whatever hearing to follow the order established on the agenda. And so the comment that I would like to offer is still at this point embryonic and very much in a draft form in my thoughts. So I would appreciate some extra time. Thank you.
Okay, we'll move on to a few others here. Esther Pat.
This is Esther Pat. Can you hear me?
Yes, thank you.
Great. I live at 706 South Kohler, and I want to comment on an important issue that is part of the city's presentation that was made by Mr. Simon. I'll tell you, as a private citizen in the 1970s, I was very active in working on passage of the human rights ordinances in Champaign and Urbana, though I live in Urbana, and I attended Human Relations Commission meetings, and I heard all the discussion, and I wish there were still a tape to establish legislative intent so people would remember what the human rights ordinance is really all about. I served on Urbana City Council from 1994 to 2005, and there were a number of times when the ordinance was attacked, in my mind, by interpretations by city staff that had no basis in the legislative intent of the ordinance and seemed to be based on federal and state court decisions, just like the reference Mr. Simon made tonight, without telling people that those court decisions were not decisions on local human rights ordinances that include conviction record and prior arrest and conviction record as a protected class, and that they're different. I think a big problem, and this isn't just in this case today, but it's been going on for about 5 years, is that some people at the city, some officials, even some commissioners, are confusing ban the box with Urbana human rights ordinance. Ban the box was progress for people in cities like Decatur and Rantoul and Kankakee that have no human rights ordinance that prohibits employment discrimination based on prior arrest or conviction record. But in Urbana, ban the box is a step back. In case anyone doesn't know what I mean by ban the box, that would be the policy where an employer can check your conviction record, but they shouldn't put it on the application, and they should look at all people equally without knowing their criminal record. But then when they're ready to offer to hire someone, then they can look up the record and then talk to the applicant about it before they make their final hiring decision. As Mr. Simon explained, that's legal for any job that either a federal or state law or regulation requires a criminal background check. But in the city of Urbana, under the Urbana Human Rights Ordinance, any private employer who has hiring for any job should not ever check the criminal background record. The fact that the person has a criminal record is something the employer should not factor into anything, not even their final decision, and they really have no business talking to the applicant about it either. It's asking about an applicant's criminal conviction record or arrest record is like asking about their religion or their sexual orientation under the Urbana Human Rights Ordinance. And the only people who can change that interpretation of the ordinance are the city council, if they were to pass some language changing it. So I hope as you move forward in your that's not your main issue today, and I know your final decision today is going to be about something else, but the purpose of this provision of the Human Rights Ordinance is the belief that the criminal justice system and no one else imposes the penalty for committing a crime. And once a person has served their sentence, the purpose of the civil rights law, this human rights law, is to make sure that landlords, realtors, lending institutions, employers, and owners of businesses that are open to the public do not effectively extend the sentence that was imposed by the criminal justice system by denying the essentials of life, housing, a job, and use of public facilities. And that's a principle that should not be compromised at all. As far as what to do with City of Urbana as an employer, I would really love it. I know this will happen. If one of the Human Relations Commissioners who hears my voice right now would request an agenda item on the next agenda of the full meeting of the commission to discuss a resolution by the Human Relations Commission to the mayor and the city council asking that the city please change its hiring policies and practices to be consistent with the standard that the city human rights ordinance requires of private employers, and that they should do it as a matter of integrity and commitment to the principle that their law supports. I think they'll do it if you ask, and I went into this whole thing about them ban the box because I want to make sure, I'm hoping that in asking them to do that, we don't get into a re-examination of, do we want to really treat criminal record the same as we do race, religion, and sexual orientation, or do we want to make it something different? And making it something different because people are uncomfortable with it is the essence of prejudice and unlawful discrimination. So please, please, Human Relations Commissioners, help me make sure we don't go there. Thank you very much.
Thank you. Jason, could you please invite the next public participant, please?
Yeah, the next person is Grace Wilkin.
Hi, can you hear me?
Yes, thank you.
My name is Grace Wilkin. I'm an Urbana resident, and I wanted to say thank you for listening to the public and extending our time to speak. I hope that you have an open mind when listening to everyone today on the issue of discrimination in city hiring and job posting. Wanted to say this seems obvious, but saying that applicants must pass a criminal background check for this job is discrimination based on criminal background. I feel like that seems pretty obvious to me, and that posting it in the job description turns away anyone with a criminal background, even if they might not have been discriminated against, they would just never apply in the first place. And if the applicants won't be discriminated against, then why do we need to ask the question in the first place? There will be intentional or unintentional discrimination if the evaluators know of someone's criminal history. And if you believe in our laws and justice system, then we have to let people serve their time or pay their fine and be done with it. You can't be judge and jury all over again when it comes to employment. Our human rights policies protect against this kind of discrimination for housing and any other jobs. So why wouldn't it apply to all aspects of jobs and hiring in the city itself? And it sounds like it does. Why wouldn't it? The city of Urbana needs to be an example of human rights and non-discrimination, regardless of what we're legally required to do. So I just wanted to keep those things in mind and hope that you can continue to look into this issue. That's all. Thank you.
Thank you. Jason, if you could, please.
And
Thank
next
you.
up is Jane McClintock.
Hello, this is Jane McClintock, 707 East California in Urbana. Can y'all hear me?
Yes, we can. Thank you.
Oh, thank you. And I'm going to pass to Danielle Shenwith, who wanted to say something, but I will be brief, so I hope we won't throw off your numbers. I just want to encourage the city of Urbana to hold themselves at least accountable to the standards that, that we've set for the citizens of the city. The city should be setting an example. So let's at least hold ourselves accountable to that non-discrimination that we would ask private employers to. And in terms of, I feel a little disappointed by this hearing, as it seems like we're, arguing over really piddly things. And I hope Mr. Simon could please consider acting with a bit more professionalism and not, that I felt like there was a bit of a personal attack and, wasn't totally necessary. But thank you all for speaking about this and for taking the time to listen. Here's Danielle.
Hello. Can you hear me?
Yes, we can. Thank you.
Yeah. So, I think if you could start the clock since I'm a different person. Thank you. So my name's Danielle Chenoweth. I live at 412 West Illinois Street in Urbana. I serve as the Cunningham Township Supervisor. I'm also on the Board of Health and the Housing Authority Board. I wanted to speak. I was unaware of the issues till I started hearing this evening's conversation. I actually was dialing in initially because I have sent to the chair and the mayor and the chief administrative officer proof of a landlord within the last month declaring in writing that they screen out people based on criminal convictions. So it's a very clear situation. It's not old. It's not based on what they post in their publicity, which is also actionable. And I would like to see that this board, this commission, take action, not only education, but to take action when you have documentation of a violation of your ordinance. Secondly, it is improper for the city of Urbana to screen based on criminal conviction based on its own ordinance. It's definitely in defiance of the spirit of the ordinance, and I was shocked to hear that that was used in this hire. So what I want us as Urbana to really reflect on is, a law is only as good as its enforcement and execution. And every single day, poor people that I work with are stopped for vagrancy. They are given trespass orders. They are removed from public property. They are considered a nuisance, right? There's a lot of different ways in which they are policed. And yet we do not, first of all, that's a problem. That's not your problem, but it's a problem. And yet when it comes to what generates and exacerbates poverty and disconnection and homelessness, discrimination is one of the top 3 contributing factors to poverty. So it's really important that you as a commission take seriously your obligation to go after landlords and take action. And I will tell you, as soon as you do, word will get out. But we are waiting for you to take action. And I provided that proof, and I am requesting action on that proof. And if I need to submit a formal complaint, I can do so, but I don't feel that that's necessary, given that I've given you the information you need to act. Thank you.
Thank you. Jason, could we please have the next public participant?
Yeah, the next one is John Kraft.
Can you hear me?
Yes, we can. Thank you.
Okay. I'll be brief and only say that when it comes to discrimination, bullying, or any other thing, it is every person's right to identify and make a complaint alleging discrimination in the workplace. I spent 22 years in the military. That's one thing that they beat into our heads from day one, was that you don't have to be the perpetrator or the victim. If you see it, you report it. So in cases of discrimination, whether it be, in verbal or advertising for jobs, if somebody believes that other people were discriminated against, it's their duty to report it. And on the same note, it's the duty of the commission to investigate all reported allegations of discrimination. And I wish you would do that. You probably could have done it already without arguing over, standing and all this other stuff that the attorney was arguing about. It just makes the city look bad in my eyes when they spend so much time arguing against investigating an allegation of discrimination. That's all I have. Thank you.
Thank you.
All right, our next speaker is Tracy Chong.
Hi, can you hear me?
Yes, we can. Thank you.
Okay. Hi, I'm Tracy Chong, resident of Urbana. First up, thank you so much for giving us the space and time to speak. It's really a relief to be able to speak slowly and voice our thoughts. And I'll try to make this as succinct as possible. So it's very concerning if Urbana's human rights laws do not apply to the city of Urbana itself. The Human Relations Commission has an obligation to oversee fair and non-discriminatory hiring of city employees. It is mandated by the HRC ordinance. The city needs to hold itself accountable. Discrimination brings down a whole society, not just the person personally victimized. Local government, the foundation of society, needs to hold itself to the highest standards. For the City Attorney James Simon to argue that there is no probable cause for the complainant just because he has not been personally victimized defies logic. It also goes against all moral and ethical values of the City of Urbana. I think it was also very disrespectful that James Simon called a concerned resident a night Arab searching for a cause. Why is there even a need to label, perhaps negatively, a genuine want to improve our city? I don't know, I feel really disheartened by that. The city should remove the language in job ads requiring an applicant to pass a criminal background check so that people who have a criminal history would be comfortable applying for the advertised positions. We need more diversity in the applicant pool and should not be turning away potential employees. This should also be the case for boards and commissions. For example, it would actually be beneficial for residents with convictions who have been dragged through the police and justice system to hold positions like the Community Engagement Coordinator and also be on the Civilian Police Review Board. We need diverse thoughts, opinions, and experiences to represent the residents of Urbana and be effective in addressing the social and policing issues we are experiencing. The current HRC hearing system is flawed. There are biases that put the complainant at a disadvantage. City Attorney James Simon is assigned as the role of investigative officer. I believe this role should be filled by someone who is impartial to the investigation and has no conflict of interest. And I hope this is taken into account for future hearings. James Simon is the city attorney. His client is the city. And it is in his interest to present his interpretation of the city ordinance that best suits his and his client's interest. This would be already concerning with an ethical attorney, but what Simon does best is twist logic. He picks and cites sentences which he thinks makes his point, even though if you actually read the statements he picks in full context, it usually means the opposite. His tactic has been used multiple times to protect the city and city staff when they break FOIA and OMA laws. And you see it in action again today, over and over. Besides that, the HRC ordinance does not allow the complainant to have legal representation or any aid during the hearing, whereas the respondent can have representation and even cross-examine the complainant and witness. Maybe in the future you guys can do something about this. I've also a comment about what James Simon said, where he said it is where he said that FOIA has nothing to do with the HRC. I beg to differ. Case in point, when cases like this are being investigated by the HRC All police misconduct cases are being investigated by the CPRB. There's often a defense by the city that the complainant has not provided enough evidence. Residents have had problems obtaining public records from the city. I personally have had problems obtaining public records from the city. It takes a lot of willpower and time, and often so much persistence to go through the Public Access Counselor appeal process to get records from the city. Even if the complainant is successful in obtaining these documents, the time to submit a complaint has usually elapsed. That's why boards like the HRC have subpoena power, because it is expected that city employees will try to withhold documents that can be used as evidence of misconduct. Finally, despite being disallowed by the HRC ordinance, Simon does make a point about being concerned that a person convicted of identity theft is allowed to handle personal financial information. That begs the question, though, should people who have broken public record and open meeting laws, as confirmed by the Illinois Attorney General, be allowed to hold positions such as city attorney or FOIA officer for Urbana? Please do the right thing as independent hearing officers. We need to let this complaint be investigated. We cannot block the investigation of this complaint just because it's a difficult and uncomfortable decision. Discrimination affects every member of our society. And as you've heard from different members of the public, we urge you to allow this complaint to be investigated. Thanks for your time.
Thank you.
And now we have David Dorman.
Hello.
Good evening.
I'm a retired resident. I live at 613 West Delaware, and it's in listening to this whole thing. Like a lot of other people, I was very disturbed that that the lawyer for the city was simply. It seemed like his job, as he perceived it, was simply to oppose any complaint. And he did his best to oppose it on whatever technicalities he thought might apply. But if you just talk common sense, it seems that a job posting that asks, that says that a person must pass a background check clearly is asking for people who have not had, who have not been convicted of a law. That's just would be anybody's interpretation. So it seems on the face of it that it is discriminatory. And I don't see beyond investigating the particular jobs and whether it's really, well, even if it's relevant for those jobs, to actually put it in the job description rather than doing what I think was it Esther Pat who used the phrase, I can't remember that phrase that she used, but that you do a background check for some jobs that would require it. But there's never a reason to put it in the job description itself. So it seems to me that I don't see why the Human Rights Commission wouldn't direct the city to change its job descriptions to eliminate asking for that applicants pass a background check. Nobody's talking about fines here. There's just a practice that should be eliminated, a discriminatory practice. Thank you.
Thank you.
And now we have Danny Otto.
I'll be very brief. I'm a little surprised that the city attorney is the hearing officer on this case. What I heard looked more like a a lawyerly brief for the defense rather than someone who is trying to understand the complaint, hear both sides, and come up with a recommendation. The testimony we've had from Esther Pat, I think, makes very clear the legislative history and the legislative intent of this. And I don't know why this is so complicated. The complainant made clear he's not looking for any fines, so there was a lot of obfuscation about trying to levy a $500 fine and against the city, and the city be responsible for collecting it. The basis of the human rights ordinance should be to make sure that human rights are not violated. It seems to me like the role of the city attorney, which is not primarily litigation, is to advise the council and point out to the council when there are weaknesses in council legislation where things are inconsistent with other aspects, and give them advice on how to make things congruent so that the intent of the legislation can be met. So I was really not at all convinced by his presentation, and I have to say that Chris Hansen, I think, was much more compelling. Thank you.
Thank you.
And it looks like the final person with their hand still raised is Sarah Nixon, so we'll go back to Sarah.
Okay, I will do my best to comment. Hello, my name is Sarah Nixon, and I'm a resident of Urbana-Champaign. And I would like to offer a brief comment. First, I think it's sad and embarrassing that we are gathered here to debate for hours whether or not Urbana's human rights laws apply to the city of Urbana itself. Employment discrimination against people with criminal backgrounds is wrong. Urbana policymakers know that this is wrong. Sorry, lost my notes. Bear with me, please. Yes, Urbana policymakers do know this is wrong. Why else would it be so clearly spelled out in our human rights ordinance? And even if it's technically legal, there can be no moral justification for the city violating its own ordinance, and the city should not be holding itself exempt. Urbana staff should instead be standing tall as a model in upholding human and civil rights in all cases. I believe that reasonable provisions and exceptions to the general rule may exist. For example, crimes of violence may be accepted. Financial crimes might perhaps be considered when hiring for an accountant or treasurer position. But blanket policies that discriminate are unacceptable. And, excuse me, if the Human Relations Commission has an obligation mandated by its ordinance to oversee fair and non-discriminatory hiring practices in Urbana, then that obligation must extend morally to overseeing the employment practices and policies pursued by city employees. As one of many Urbana residents scarred for life by a wrongful arrest record and a wrongful criminal conviction now vacated, the matter at hand holds personal meaning, and I could not let this hearing go by without contributing my voice, however weak. And I would like to make a few closing points. I echo the points made by Ms. Tracy Chong about, and Mr. Hansen about hurdles and wrongful barriers erected that obstruct complainants in moving forward with their complaints. How can it possibly be fair to impose a scenario on a complainant where they are up against a lawyer, a legal professional, as someone pointed out, with many, many years experience, where they themselves are being denied that same expertise. And yet the hearing format seems to follow a sort of court hearing or legal proceeding format. So that's just wrong. I also agree with points made by Ms. Esther Pat, who requested that a resolution be introduced by the Human Relations Committee or commission to ask the mayor that the city change its hiring policies to make it consistent with the ordinance. That sounds to me like the single most sensible suggestion I've heard all evening. I would like to also comment on the characterization of Mr. Christopher Hansen as a knight errant. So Mr. Hansen may well be a knight, but he's certainly not one without a cause, right? This is self-evident. And we've seen over and over and over again, Mr. Hansen simply asking the city to hold itself accountable, hold itself to the highest standards, and he takes on willingly a very unpopular role in his perseverance. Again and again, he is shut down. He is silenced at city council meetings, and yet he pushes on. And I applaud his moral rectitude and his courage in shouldering these burdens for the city, for the citizenry of Urbana. I hope that his tireless crusading will result in a sensible and fair solution to this problem. And I also would like to close by noting that Mr. Simon himself acknowledged this evening that he and Mr. Hansen might agree on changes to the HRC ordinance. And so I sincerely hope that all of these efforts could result in a serious and amicable dialogue and problem-solving session. So thank you for your time.
Thank you.
And I do think that we had one more person raise their hand during that time. So the final person with their hand raised is Lance Pittman.
Hi, can you hear me?
Yes, we can. Thank you.
Thanks. My name is Lance Pittman, and I live in Urbana. First, I just want to say I completely agree with everything that Tracy Chong said and most of the other speakers before me, so I just want to say that. I have a question that I'd like the commission to consider. I'll state it now. Why do people have criminal backgrounds? And I'll repeat that. Why do people have criminal backgrounds? Well, there's no one single simple answer, but I can think of several big ones. Because of poverty, because of untreated mental health conditions, because of violent cops who need to justify their actions after the fact. Just ask Aaliyah Lewis, who was beat up by Urbana cops and charged with felonies. Because of state's attorneys with biased agendas, because of just being in the wrong place at the wrong time. Ask Mr. Hansen, the complainant. But even in cases where someone is, quote, guilty as charged, unquote, and without extenuating circumstances, we still cannot say that past behavior is necessarily indicative of future behavior. That would mean that education is not possible. And I hope that no one who lives in the home of University of Illinois actually believes that. In my day job, at least before COVID, I interacted with incarcerated students on a regular basis. And I can say that the stereotype of a person who's been convicted or who is incarcerated as someone that you need to fear, it's just not true. I've never felt unsafe visiting, for instance, Danville Correctional Center. Now, I'm not a lawyer, but and you know, I've listened to the arguments. I tend to come down on the side of Mr. Hansen, but even if Mr. Simon is correct in his legal opinion completely, I believe that the city needs to do better than that anyway. It needs to do better anyway. If you don't intend to discriminate based on criminal background, then why even waste time or money on a background check? The only reason to do a background check is precisely to discriminate based on criminal background. It's like running a credit report. A bank does not run your credit for the fun of it. The entire point is to discriminate to whom to extend a loan. A background check is no different. Let's end this type of discrimination in Urbana. Thank you. Bye.
Thank you.
And that is everyone who has raised their hand for public input.
Jason, thank you very much. And thank you all for your comments and for participating tonight. We appreciate it. We did make an agenda revision a little while back, and so we are now going to have some questions from the hearing body to our presenters. Jeff, would you like to begin?
Sure, I'll start. Again, I'm not on the Human Rights Commission, so this is just I'm sort of out of the blue, and so I'm playing catch up here, and I'm not a lawyer either. But I did have a couple of questions. For instance, and I'll just do them randomly, is there a city policy in writing that specifies how to use a criminal background check, i.e. how to advertise it, and how to use it in the hiring process? And is there a policy that would cover credit reports and media checks like Google and things like that? Is that part of some training for people that have the hiring ability in the city?
I can't answer whether there is a written policy covering these issues. In terms of criminal background checks, the HR Finance Department follows the guidelines published by the Equal Employment Opportunity Commission on the use of criminal background checks when conducting hiring, and they're pretty lengthy. In terms of credit reports, I have to admit I can't speak to that issue. However, I can say, for instance, with criminal background checks, they are not, I've been told, not required or not included on every job app or job description. In this instance, with these two, the two city employees, Elizabeth Hannon, who is director of HR Finance Department, and Elizabeth Borman, who does our hiring, sat down to discuss what these two individuals, or whoever fills these positions, will do, what these jobs are going to be. Now, one of them it was an update to a job description from long ago, and the individual, as I understand it, is basically our benefits coordinator. That person is going to deal with a lot of very personal information from from employees, employee information. I listed some of it, but it goes far beyond that and all. The other person, I'm not familiar with, other than the job description from their role, but when I went through the job descriptions on both of these individuals, they clearly are going to be involved in personnel matters. The other job description, that person's going to have interaction in the context of employee discipline. Obviously a very sensitive subject. The way they approach it is they just, they don't do a criminal background check for the purpose of eliminating people. They check their background, and in many instances, the background check, I had to go through a criminal background check for my position. And I don't know what they found because I've never done my own criminal background check. But it isn't an automatic denial of employment. It depends on what's found in relation to the job. And I think one of our public commenters brought that up. Would you hire somebody who has been convicted of bank fraud, of embezzlement, those kinds of things, as the director of finance? Would you hire, as a housing inspector, somebody who has a history of burglary, of breaking and entering and stealing? Maybe you would. I don't know. I mean, that's a decision not for me to make. Okay. My job here was to interpret the ordinance as it's written.
But as far as you know, there's nothing written about
well,
this.
other than the EEOC guidelines,
okay.
I'd have to check with the HR finance department in terms of the what policies they use.
So it's sort of up to the person doing the hiring, perhaps, as to how they might use it.
No, they follow EEOC guidelines.
Well, okay, all right. Yeah.
And those are written guidelines.
Okay, so I had another question. You mentioned in your discussion that this was an internal posting, so these things never were advertised to anybody outside the building?
They were not.
So is that
that is a common practice in hiring in the city because it allows city employees who have clearly demonstrated their dedication to the city by being employed here, gives them an opportunity for promotion or job change.
Well, no, I agree, but it seems like at the university, you have to advertise jobs. You have to tell people are available, even if you end up hiring somebody from inside. It just seemed like an odd thing to say that they never got outside. Well, the second part of that question is, though, would the line on the job description says special requirements, the applicant must pass a background check, a criminal background check. So would that be on jobs that were advertised outside? Or?
To my understanding, yes, that would be.
Okay, so these two perhaps were internal, but that really doesn't, other jobs would normally have that on there.
Some jobs have it. It depends on what the job description, what their duties are going to be in terms of whether it makes sense to conduct a criminal background check. And whether it's internal posting or an external posting, to my understanding.
Okay, so
I'm not involved in the hiring process.
I'm only, I started reading a bit about this. So when you advertise special requirements must pass a criminal background check, do you specify what kind of criminal background might disqualify an applicant, or do you just say a blanket must pass a criminal background check?
To my understanding, they don't specify what findings would disqualify somebody.
Okay. Again, you're a lawyer and I'm not, and I'm probably out of date, and this has been, superseded, but I found this Department of Labor thing called the Job Opportunities for Qualified Applicants Act. It's an Illinois act. 820 ILCS 75 that specifies that you're not supposed to use a background check until you're making an offer for a job.
And that's the way it's done here. A contingent offer is made, then the criminal background check is undertaken, and then once the information comes back, the hiring person, Ms. Borman, reviews the criminal background check to make sure it's accurate, because we do find things that are inaccurate on these criminal background checks.
This law specifies that you are allowed to use criminal background checks for specific reasons, financial reasons or whatever, but that it's not a blanket kind of thing. And it does cover cities and private employers and stuff.
Yes, it allows.
No, it just seemed like you didn't mention that. That's the Illinois Department of Labor. You didn't mention it when you were talking about other avenues for this complaint, and it seems like that would be a pretty appropriate one.
Yeah, I'm not familiar whether there's a complaint process.
Oh, there is, and there are fines and all sorts of things, yeah. Okay, let me just check and see if I got anything else that I need to ask you. The reason I asked about credit checks and media checks is like when you think of some of the things that are going on in China, where you have to pass a social media test and all, and I mean, it just, the criminal background to us, it seems like pretty isolated, but this could be sort of a slippery slope if,
I don't know whether we do media checks, Google somebody's name. I don't know whether we do credit checks. We might if it involves somebody, handling
Right.
money who's gone through bankruptcy.
Well, a credit check probably is something that, there's a record of it, but, researching somebody on Google, for instance, myself, like for years after I had the timidity to sue the University of Illinois, that was the first thing that popped up on my, and I'm like, I'm English, man. I don't do these kind of things. But that was how I was labeled as somebody that would sue my employer.
Well, that's part of a problem
but
with
but I would
social
encourage
media
you.
checks.
I mean, as a lawyer, I would encourage you to have the city design something that really specifies how criminal background checks and things like that are used, because it's gonna come back to bite you if you don't. I mean, and I know how casual it can get when you're, well, let's look this person up, that kind of thing. I'm sorry, that's trivial, but that's all I needed to know. Thanks, appreciate it. And I didn't have any questions for you, sorry.
Can I address some of the issues you just
Oh,
raised?
yeah, sure. I mean, it's all right with me, yeah.
Yeah, so I think the answer to your question to Mr. Simon was no, Urbana doesn't have any written policies that it follows. And I'm still confused why we're talking about outside, less stringent anti-discrimination laws. Urbana has its own law. This is a meeting of the Urbana Human Relations Commission in regards to the Urbana Human Rights Ordinance. And I think the answer you received there is that the Urbana Human Rights Ordinance doesn't provide for any type of language on how we might discriminate based on a criminal background check, because it simply says, do not discriminate based on a criminal background, period. There's no meaning in us going on a search around the country for less restrictive hiring practices when we have our own, and that's what we're here to discuss. And you also brought up, or it was brought up, that this was only on 2 job descriptions that were circulated internally, and that's actually not the extent of it. I went back and found another one in June for the Community Engagement Coordinator, where it also required a background check, and I believe that position was already hired to someone outside of the city. And I haven't gone back and searched further, but as I find them, I suppose I'll submit new complaints. So that's that. I think discussing how Urbana's ordinance maybe relates to other employment practices or laws or anti-discrimination laws is interesting, but I just don't see how it relates to how we're going to vote and decide here in the Urbana City Chambers. Oh, and one more note. Mr. Simon said that we might not hire someone to handle money if that person had been through a bankruptcy. People can go through bankruptcies for all sorts of different reasons that are not their fault at all. I have no idea why we discriminate based on that kind of information. That sounds wrong to me as well.
Let me respond to a couple of things. I did not mean, and if I did imply, then I wasn't as clear as I should be. I'm not saying that the city should refrain from hiring people who've been through bankruptcies for any position. People go through bankruptcies for all kinds of problems that may have nothing to do with money management. I mean, back when people were going through bankruptcy left and right with what I call the Great Depression 2.0, some people call it a recession, back in 2008, 9, 10, people were filing, about 50% of bankruptcies were due to medical. They couldn't afford their medical. So I didn't mean, if that's the interpretation people are coming away with, I clearly didn't mean that. Maybe I could have chosen a better example. So I apologize for that confusion. In terms of, Mr. Hansen is absolutely correct, and I don't think I said anything different, that in some jobs, when they are posted externally, there is a reference or a, quote, special requirement, that's what's labeled, at least in these two, to a criminal background check. It depends, as I say, whether it's internal posting or external posting. My presentation was based on the ordinance, and we got a lot of very good public comment on where this ordinance might go. I will say it's not my job to go to the council to advance changes in the ordinance. That's up to the mayor and the policy people and the city administrator and the city council and you all, if you think there should be changes in the ordinance. I may be called upon to draft the language, and I will draft the language. I've drafted a lot of the ordinances that have gone into effect and control city business and public business, like the liquor ordinance. That was a collaboration. So, and if somebody asked me or tasked me with drafting that, the mayor or the city administrator, I'd be, making changes to this. If some, it's not my role to initiate that. I'm not an initiator. I'm a facilitator, a drafter, or providing legal advice. If somebody would say, I want you to draft an ordinance that prohibits African Americans from applying for jobs in Urbana, I would be the first to point out, no, I mean, you may want that, but we can't do that. We're not, so I can't draft that kind of an ordinance, nor, so I would provide the legal advice. But, if it's a legitimate, legally accepted, permitted ordinance, there are many times I'm asked to draft it.
Thank you. Jeff?
Sorry, I just had,
There's no-
so were these jobs civil service?
I didn't catch that.
Were they civil service?
Yes.
Yes.
Okay. Both positions, both descriptions had to be approved and were approved by the Civil Service Commission.
So I know it's not absolutely pertinent, but I think it is in a way. This sort of internal versus external search, when I was at the university, man, you can't do a search without telling the world that it's available. You might not tell them very well, but you're supposed to go through the motions of saying this job's available. I'm just wondering how you get away with just posting the job for people inside the city.
I think
it just
it's
seems a little dodgy to me.
Yeah, I think it's not necessarily a written policy. As I say, I don't read every single policy that's ever been adopted by the city until an issue about a policy, and then I ask for a copy of the policy and I interpret it. But it's a policy either in conduct or in writing, and as I say, I don't know if it's in writing, where we want to allow our employees to advance. And if they qualify for the position, and I will give you an example. A number of years ago, I had to hire somebody for a position in my office in the legal division. And we ultimately went to the outside because the people who applied didn't have the unique skills that we required. But we wanted to give people in the city a chance, and that's the policy. Now,
well,
whether that's wise or not, I guess we can debate that.
I could see a policy that, put people internally at the head of the line, or gave them an interview or something like that. But if you're hiring only a certain kind of people, then a policy like that would perpetuate you hiring or promoting those people that. It perpetuates a culture that perhaps needs some infusion from the outside, or should be able. You should be able to break down barriers of cultures. That,
well, we certainly hire plenty of people from the outside.
I know. Yeah, I know.
But I'm not sure what you mean by certain kinds of people.
Well, that if you had people who are, legal people that always worked for the city, that maybe, got a particular kind of background, I don't know. But I can't believe that civil service jobs are not advertised outside the city. It just seems kind of unusual to me. I mean, maybe.
Would it be possible for us to move on and stick with
sorry, sure.
the actual reason we're here? Thank you very much.
Sure.
Thank you.
I'll just answer one quick point, and maybe as a point of interest. The Urbana ordinance also doesn't allow you to discriminate based on source of income. So if the suggestion is that, oh, we're only hiring internally, that really is another form of discrimination based on source of income, because you're saying we only hire you if your source of income is currently the city of Urbana. I think you're spot on by saying it's a little dodgy. I mean, it sounds wrong to me too, but I agree it's not really exactly what we're here to talk about.
Thank you. Aisha, do you have any questions for either the officer or complainant?
No, I could make comments, but I think that would be during hearing body deliberations.
That is correct. Thank you. Likewise, I think I have no questions as well. And so that means we will be moving on to deliberations now, please. And since you alluded to it, Aisha, if you'd like to please share your thoughts. The floor is yours.
Well, I want to keep this as short as possible.
Yes.
My belief is that Attorney Simon basically focused on sort of procedure, semantics, and there was a bit of ad hominem going on, definitely. But I will, I'll put that aside. Mr. Hansen, in fact, presented his arguments very clearly. I am a former Urbana Human Relations Commissioner, and I was also there when they made the changes to the Constitution, discussing, we had all the long arguments and talks and things about people's past and regarding, convictions, etc. And I believe that there is just no way that this should be on this whole thing about the background check. It is, I understand that the attorney, says that's not what it means, or that's not what it says, or that's not what it's intended, or he's merely going with what it says and it's not his job to interpret otherwise. But I believe that, every month we used to meet, they still do, and looking at all the companies that do business with the city of Urbana to decide if they were adhering to the Constitution and to the, both in spirit and literally. And it just boggles my mind if we think that somehow that doesn't apply to the city of Urbana. And my belief is that most people have come to the same conclusion, and that, yes, I understand the attorney is the one who is defending the city of Urbana, but it is odd. It is just so odd, because there is obviously a, I guess you would say, a precondition, that is, of defending whatever actions took place in the past, rather than, it's not his job to change anything, but that these are my thoughts.
Thank you. Jeff.
So I appreciate Mr. Simon's position, and it is kind of strange that he's presenting this argument when he's the lawyer for the city. I don't think you can do both human relations officer and legal counsel. The legal issues, certainly, I'm sure if this went to court, he would probably prevail in that some judge would say there's no jurisdiction here, or it's, it doesn't apply to these people, and you could argue over who's an employee and who's an agent and who's an employer and all that sort of stuff. But I think the legal arguments that he's made are not what we're talking about. The city should set an example. One of the participants suggested that the city, I think maybe Esther, that the city should be an example of how to do things, not fighting and splitting hairs about whether this was discriminatory or whatnot. And we know that criminal background checks are an issue, and it's a chilling issue. When it says that in the job description, and you look at the job description, you don't know whether that means if you, got convicted of taking something from the grocery store when you were in high school, whether that's going to matter on your being considered for the job. I think that putting that on the job description has a chilling effect. So I don't see this where he says that Mr. Hansen lacks standing. I think the standing is he's representing all of those applicants that never applied because they were scared that a background check would somehow eliminate them, and that's what discrimination is. It's fear, and so I don't find Mr. Simon's arguments compelling, even though they're probably legally, if we went to federal court, he'd probably be able to maintain this. That's my comment.
Okay, thank you. And I'll conclude as well, thanking both Mr. Hansen and Mr. Simon for their very thoughtful and detailed presentations. I am the current member of this body who is a member of the Human Relations Commission. I'll share a little bit with what we've been debating the last few months since these issues have arisen. And these issues have exposed that, we have some problem, at the very least, with the language in certain sections of our ordinance, whether it falls under the heading of ambiguity or vagary. And we are actively addressing that as we speak, trying to improve that. I will say, since I've been on the ordinance, issues like this have come up quite often, where we really thought 10, 15 years ago, we really nailed this section. And with time and with thought, we realized, no, we did not. We've got more work to do. And this case has exposed another instance of the work the commission has ahead of us. Now, this is not going to be popular. It's not going to be liked. And actually, before I get to that, I'll say, in this instance, we are not meeting the spirit of the ordinance. The ordinance covers we believe, should not exclude folks, and certainly not the city itself purporting to withhold and represent that ordinance. For whatever reason, the language on the books makes that quite challenging for me personally. And this hearing is attempting to address the facts of the case and detail and not get and stay within those parameters. But we are violating the spirit of the ordinance on some levels, or not violate. Pardon me, I'm misspeaking. I'm getting ahead of myself. We are not meeting the spirit of that law, and I don't think, and I think Mr. Hansen has demonstrated that he does not have to personally be impacted by this for him to bring forward the issue, to raise the issue to all of us, to the community, to the commission, to the city. So that's somewhat clumsily attempting to sort of frame where I'm going, sort of the basis of my opinion. So, with that being said, deliberations are concluded. We are now going to have a roll call vote. I'm going to ask 2 questions. I'm going to ask each presenter of the panel, or each member of the panel, to either concur, say sort of yes or no. So that first question would simply be, do you concur with Mr. Simon's determination that the complainant has no jurisdiction in this issue. Tamara, could we please have a roll call?
Daniel Larson,
I concur with his determination.
Aisha Lamb-Sobe,
No.
Jeff Bant,
No.
Thank you. And the second question is, do you concur with Mr. Simon's determination that there is no probable cause? Could we please have a roll call vote?
Daniel Larson,
I do not concur.
Aisha Lamb-Sobe,
No.
Jeff Bant,
No.
Thank you. Thank you all. So, in the following days, we will, as the presiding officer, as well as staff of the city, we will be producing the official order that outlines the hearing body's decision, and that will be posted within the, I'm not sure of the exact time frame, but I believe it's 7 days. We will have that out shortly, and we will go from there. So again, I want to thank everybody for their time this evening. I appreciate all the public input, and I'm very grateful to Aisha and Jeff for lending their time and their knowledge to this hearing, and we are going to adjourn now. I hope everyone has a nice evening, and be well.
Thank you very much. Bye-bye.
Thanks.
Thank you.
Thank you. Good night.